Under Section 7, there's another form of constraint. It's not just rationality. In the BC motor vehicle case, the court didn't find that using absolute liability to prohibit certain conduct under threat of imprisonment was irrational. It found that it was unjust. It was unfair. It's very rational, in fact, very efficient. In fact, administrative efficiency is the whole rationale for the use of absolute liability. But the court said the principles of fundamental justice prohibit not criminalizing, but using imprisonment, the ultimate deprivation of liberty, for a conduct that doesn't have a sufficient fault element. What we're being asked today is whether there's a parallel principle of fundamental justice that prohibits recourse to imprisonment for conduct that causes so little harm.
What the court was looking at in the motor vehicle references is whether someone could be imprisoned without mens rea. And this court decided that mens rea is, the need for some level of mens rea is a principle of fundamental justice. That's a different question than whether a law which requires mens rea, requires actus reus, is unconstitutional because of subject matter. In my submission, the motor vehicle reference only goes as far as its facts take it. And this court in other contexts, of course, has looked at the ingredients of offenses. In Ruzick, you looked at the question of a defense, duress. How does the charter play out there? But we're dealing here, in my submission, at a more basic level, and that's whether Parliament can even, leaving aside the necessary ingredients that have to be established, whether the subject matter is such that it falls within the legislative competence of the Parliament of Canada. And in my submission, before a subject matter can be removed from the jurisdiction of a legislature, a subject matter that has been otherwise conferred by another aspect of the Constitution, it's a fairly rigorous standard, which is why I advocate.
Mr. Frankel, though, it seems to me that these are two different matters. The question is there a principle of fundamental justice that there has to be a sufficient level of harm before the state can incarcerate, not regulate, not prohibit, not fine, not sanction in any other way, but to access the ultimate deprivation of liberty? We say there is a principle of fault. You cannot imprison someone who is not at fault in the sense of lack of mens rea. Isn't there a parallel principle that says we cannot imprison someone who has not caused harm, at least to a level sufficient to make imprisonment a rational response?
Well, rational response. Is the legislation rational? That's the position I advocate.
You seem to use rational and reasonable in an interchangeable way.
No. Well, if I did, Madam Justice Descamps, I misspoke. When I was using reasonable, I was trying to draw, perhaps as I want to do in this court, another bad analogy between the recent administrative law cases.
Wouldn't reasonable be the proper way to evaluate it?
Well, again, it may be a matter of semantics, but in my submission, a rationality test more comports with a constitutional standard. But I mean, legislation that's reasonable is likely to be rational, and vice versa. My position is that although harm may be a factor to be considered in determining rationality, harm is not the test, and that the test has to be an overarching test because we are dealing here with a legal principle. It is a legal rule that governs and will circumscribe the use of penal sanctions. So it cannot be one rule for one thing. In my submission, it cannot be one rule for one thing, one rule for another thing. There has to be a template. There has to be a yardstick.
Well, I'm not so sure. In the common law case-by-case method, we're here faced with a harm case. And if there's a connection, a rational, reasonable, whatever we want to say, connection between that harm and the punishment, then I think a certain result follows. And we don't. I just challenge you as to whether logically it's necessary to lay out the whole template forever and go down those other roads where we might have a prohibition for a purely moral purpose or a different purpose. We might leave that open.
That, of course, is solely a matter for the court. My position is that it would be appropriate for the court, given that this issue can arise literally thousands of times, given the number of criminal, small c, large c, criminal and regulatory offenses, that the court should articulate, the test. But as a fallback, even though I take the position that the harm principle is not the overarching harm, is not the overarching test, excuse me, given the findings of fact in this case, it is my submission that if harm is to be used by as a yardstick or a baseline, that's been satisfied here. So even on a more confined test, this is valid federal legislation. And the fact that there may be other models that Parliament could have or in the future could choose to use does not affect at all the current question before the court, which is whether this model meets constitutional muster. So,
doesn't your acceptance of rationality, your advocacy of rationality as the test, let in your friend's position, which is that the response is wholly disproportionate and therefore rationally linked to the level of harm identified?
I take issue with the characterization of the legislation as being disproportionate. In this
Apart from this case, in principle, do you accept that as part of your rationality analysis, that there has to be some proportionality?
In my submission, if one is going to go to proportionality, one should, as in the context of Section 12 of the Charter, set the bar higher. This court in the minimum sentence cases has said it's gross disproportionality. That a disproportionate sentence, if Parliament or a legislature provides for a sentence that might be viewed as disproportionate, or a disproportionate sentence is imposed, that doesn't result in a constitutional violation. Because again, perhaps reasonable people can differ over certain lines. So the bar has to be set much higher. If I might make a
accepting that, would you say then that, based on your principle of rationality, if the court were to conclude that the response to the level of harm demonstrated is grossly demonstrated, that would violate Section 7?
Do I get a chance to go back to Vancouver and think about that?
If you wished, we could take a short 10-minute break now, and you can think about it for that long. This is a day to be generous, I guess.
Thank you.
Or you can carry on. It's up to you.
I'd want to think about that.
Okay, well, we'll rise for 10 minutes.